statutory discovery as well, but in any event.
Well, tell me what you're
Yes, Your Honor.
referring to there as well.
Yeah, the state has an affirmative duty to turn over to the defense exculpatory or favorable evidence, whether affecting guilt, innocence phase, or sentencing. Quote, this in turn means that the individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf in the case, including the police, Cosby, Woodley, United States Supreme Court, 1995. And Ms. Ellis used to be at the Innocence Commission. She knows this very well. The city's records, she's required to know what's in them. These are medical records. They may be, in addition, having represented folks over at the police department, those records are voluminous. The fact that she doesn't know whether they exist, there's the gentleman right here, the officer, she can ask him. They have a bevy of investigators. We have folks in the DA's office right here in this courtroom. There's just me. I got a pen. They got an investigator sitting right there. They got two prosecutors. They got all these folks in the DA's office. Their office is up on the 8th floor, and the gentleman knows the answers right there. All you have to do is get on the horn to police attorney, to City Hall, be a simple call. They could have done that. They did not do that. They don't know the answer. They don't have the files, and it shouldn't be at the last minute. I guess it's my fault that in the voluminous records that I didn't say, you violated your prosecutor's duty to do this. It's her duty, not my duty. My duty is to my client to represent him to the best of my ability. And when we get back to that first motion to dismiss, I'll get back to how they've undercut it. But here in the middle of trial, they don't know whether he filed a workers' comp claim to be compensated for being injured. It's really flabbergasting to me. We went through this earlier with internal affairs records. They didn't know what they had. I have to file a motion. They're required to know these things. They're required by the Constitution of the United States, the 6th through the 14th Amendment. And these folks know it very well.
Well, if it's so clear, I'm sure you have a case on it. You have a case that helps me know that it's very clear.
Cosby, Woodley, United States Supreme Court.
Tell me what it is so that I can write that down. What's the name of it? Something versus Woodley?
It's Cosby, Woodley. It's in many of my memos that I've filed in this case, and I'll give you the citation, Your Honor.
Thank you.
It's a capital case, and there's a number of other cases, the Brady versus Maryland progeny for purposes of exculpatory evidence. It's their duty to find it. They have an affirmative duty to know about it. So the fact she says it's not in my file, we're not even close to this.
Mr. Charles, focus on what I'm asking. I'm asking if there is a case citation you can give me.
Yes, sir.
It kind of narrows it down to workers' compensation, so that I can, if there is, if there isn't, there isn't, but if there is, it allows me to read that and be able to,
yes,
to see what other courts have dealt with on that. All right, Cowles v. Whitley.
514 U.S. 419. The quote was 437 through 438, 1995 case about affirmative duty, and I have no reason to believe that case mentions workers' comp cases. It deals with exculpatory favorable evidence. My argument as to the statutes, North Carolina statutes, if he's injured and there's
still outside of the presence of the jury. I hear from either of you as anything that you want to add to what you already said related first to the issue for the Brady material. Potential Brady material was not forthcoming from the district attorney's office relating to a workers' compensation claim matter. Mr. John.
Yes, Your Honor. It seems that I already had a case that I wasn't thinking of, State versus Dorman, and this was when these two prosecutors were not in the case. It was the prior prosecutor, and I suspect we talked about this case because I have things underlined. It's State versus Dorman. It's Court of Appeals case 737 Southeastern 452. 2013 case out of all places, Durham, North Carolina. It involved Lawrence Campbell, our public defender, the gentleman who appointed me to represent Mr. Riley. And it involved the DA's office in Durham. And one of the issues in the case involved records of the State Victims Compensation Agency. So we can look to this for some guidance. And in that case, here, as to not giving us the workers' comp records, unlike this case, Judge Hudson, Orlando Hudson Jr., our Chief Superior Court judge, actually dismissed the case. It went up on appeal, and the appellate court said, well, you need to look at these other remedies. So we're not even there. I'm asking for the in-camera review of these records. Presumably they exist because they have time to talk to the officer about whether they exist, and they wouldn't have me arguing to Your Honor about something that didn't exist. But if there's a question, it's a quick walk up to the witness chair for a voir dire. But in any event, there's not a whole lot of difference between victims' compensation records and statements made. I think it's discoverable, plus potential Brady material. It's material that has a regular course, just as in internal affairs records, where I used to talk about Dorman. It's instructive, but it certainly doesn't talk about workers' comp records.
The State versus Dorman is 737 Southeast 2nd, 452.
452, and I suspect I gave away all my copies last time I was in court when we talked about it. And it was more of a case on what are the remedies. Do you dismiss, do you do other things, but it does talk about records that exist with other agencies. This is a simple one because I just walked 12 minutes down from across from City Hall where my office is. But with a telephone, they could call the police attorney, the city manager, and get all this information, or they could ask this gentleman sitting right there about it. But the law is exceedingly clear that it's the prosecutor's duty to find these things out, not just what's in my file. And clearly a workers' comp case has medical records. It may have admissions by the officer about what happened to justify. There's a workers' comp form they have to fill out. Your Honor may be well aware about workers' comp records. I'm not a workers' comp lawyer, but I do know there's a form that has to be filled out about what happened. Well, that's a statement of the officer. The statements he makes, just as I presume they're going to try to get in some statements officer made to get medical treatment. There's mental health potential treatments and statements he's made, which may or may not be discoverable, but what is out there certainly is their responsibility under Cosby Whitley, and then Dorman is some additional guidance to the court about what their responsibilities are. But this is not a new question, it's decades old.
The question is whether this is sort of within the envisioned due diligence of the district attorney's office to seek information that might relate to the question and issue. That is, in this particular case, the shot that Mr. Stewart received. Well, that's within the scope of due diligence of the district attorney's office. I think we could all agree that the district attorney's office doesn't have to go out and interview everybody in North Carolina to see if Mr. Stewart made a statement to one of them. That's not what's really being asked.
Right.
The question is, clearly if it's a law enforcement agency, that sort of thing, you know, that sort of, it's presumed that the state got to deal with that. If there's a knowledge of medical records, you know, went to Duke University, then medical center, then even though the state of North Carolina does not have any control per se over Duke University Medical Center, like it sort of has policy-wise and case-wise with law enforcement, it's still something that could contain exculpatory information, may or may not. When it gets to other agencies, that's going to be the question. You know, other agencies like, let's say, schools or mental health agencies, workers' compensation, the workers' compensation framework and that sort of thing is there part of the due diligence that the district attorney's office has to examine and see if there's any Brady material? Does it extend to those sort of? They're not third-party agencies, but just in a poor way of describing them, they're not law enforcement agencies. They're other agencies, and so that would be the question. And the case that you just indicated, state. Referred to State versus Dorman, there's the State Victims Compensation Agency, not a law enforcement agency. That what you're indicating is what I'm gathering from it is that might be instructive that the Court of Appeals looked at that agency and sort of tacitly said, if they didn't expressly say, well, due diligence would have called for the district attorney's office to review that agency's information and consequently, if there's a failure to do that, there's a remedy, but the appellate court dealt with what the remedy was. It sort of addressed tacitly, maybe I haven't read the case yet, tacitly that yes, it's within due diligence, but your remedy was too extreme, or it may not have been too extreme, but you've got to consider these other remedies as well. Is that,
It discusses, actually Judge Hudson, I believe, my reading of this, my recollection of it, I just found it right before we started up again. It's mentioning these victims' rights agency, the crime commission, or the victims, I can't remember the VCA, but in any event, it's dealing with those records and what was done in this case and Judge Hudson's orders. So it's instructive as to what a trial judge should do in cases like this. Their records and their things that other agencies have.
But what you're saying is the Court of Appeals would never have addressed the remedy if they had not initially, at least tacitly, said that it's something for which you have to evaluate to determine whether there's a violation or not.
That's a much better statement of what I'm thinking. I'm having a hard time verbalizing this morning. But so it's instructive, what did Judge Hudson do? And then they said, well, he went too far to remedy these bones of the decedent were cremated. And so it's a different issue, but in the discovery discussions, what happened is instructive. But here, you're under the workers' comp for a police officer. I don't know if they fill those out at the department, but they're personnel records, just like internal affairs records are considered personnel records of the officer. So in this case, unlike 33 years of other cases I've had, I didn't get the internal affairs records. I do not believe within those records are workers' comp records. They're sealed up, so I don't know what's in there. But we were talking about internal affairs, so I don't think the police department brought those over there. But my argument is it comes from the officer. Simple matter. We can get to the bottom of this with a voir dire, but it goes from the officer. He fills it out either at the department or at City Hall, and they have procedures to help him with his injury, whatever the reason for it, whether it's self-inflicted or otherwise, for the jury to determine. But what's in there is pretty important to this case.
Let me ask my next question. I thought during what you said during your opening statement regarding that, I might have misheard, so I'm going to clarify. Did I understand you to say you had some information about this, but it's the state's responsibility to affirmatively give you this information? I don't know if I may have misunderstood as I was
Yes, sir.
making notes where you were coming from, what that reference was.
I believe under Kyles v. Whitley in the quoted portion that the state has an affirmative duty to seek out this information and determine if it's exculpatory. And certainly in talking to someone who they claim is a victim, that it's a simple matter to ask, who did you speak to, make statements to in this case that involved the police department in the city?
Well, I guess my question was, as to this case,
Yes.
did I hear it incorrectly that, or not, that you said you had this information that there was a workers' compensation claim, independent of the state providing you with anything? I may have misheard that, so that's why I want to clarify.
Yes, Your Honor. I certainly don't have any information independent that he has a workers' comp claim, other than the fact they're not jumping up to say he didn't do one. Of course, if someone's injured on the job, you're going to file paperwork either through workers' compensation or other forms of statements that involve medical records. In dealing with other clients, these type of records were kept as personnel records, part of the police department employees' file. So much like internal affairs records that the city considers personnel records, this is no different. It's a personnel record of this gentleman, and he knows whether he had made those statements. It would be a 1-minute conversation.
So the next question I have is, did in fact the defense, any of the attorneys, attempt to subpoena the records involving transcripts or other records involving the workers' compensation claim, and sort of generate its own defendant's inquiry as to any of that information?
Not that I'm aware of. I certainly didn't. My discovery requests include Brady requests for Brady material, and I list various types of Brady material and certain other medical records, medical statements. I would consider Brady. I would consider also discoverable under the 15A. So either way, it's a statement that involves this case.
All right. Well, I just wanted to know whether the defense had itself initiated any inquiry into potential, independently as part of its trial preparation or trial, investigation, had initiated any attempt to locate or gather information related to a workers' compensation claim of Mr. Stewart?
No,
arising out of this incident?
No, in fact, we would have to get a court order. It would be considered a personnel record, it would be considered a medical record, it would have to be a court order to do it. So in any event, whichever way it was done, Your Honor would have the Pennsylvania versus Ritchie procedure of Your Honor looking in camera at these records, probably unless they said you can have them under protective order, would be what would be done. The Pennsylvania.
Well, I don't have any problem with the concept of an in-camera at all, in-camera inspection. I've done millions of those. No, maybe not billions. No, I've done a lot of those. My inquiry dealt with was, if I'm addressing the due diligence requirements or scope of the prosecutor versus the defense's own investigative efforts to try to get information. And sometimes what happens is that a subpoena is issued and here comes the motion to quash from the agency or the organization, and then we have a hearing, and then if it's allowed, the judge takes it in camera and decides what's going to be released or not released, but preserves the whole record in case there's some issue about whether the judge adequately addressed what he or she was supposed to in camera. So those are the kind of things I'm also balancing there. Let me hear from the state. I got from Mr. Charnes, State versus Dorman. And who wants to speak on behalf of the state?
Your Honor, during the break, we did have a chance to get some information from Tony Smith, and what we have learned.
For the record, say who Tony Smith is.
Your Honor, Tony Smith is the police department attorney.
Thank you. All right. Okay.
And what we have learned is that the workers' comp files, which have previously been characterized in this proceeding as personnel files, are not maintained by the Durham Police Department. They are, in fact, maintained by the City of Durham Risk Management Section, specifically because workers' compensation has to do only with medical diagnosis, treatment, and payment for a city worker who has been hurt. As such, it is not then connected to the investigation or prosecution of a particular crime. More specifically, 15A-903 places the duty on the state to make available to the defendant the complete files of all law enforcement agencies, investigatory agencies, and prosecutors' offices involved in the investigation of crimes, and defines an investigatory agency as a public or private entity that obtains information on behalf of a law enforcement agency or prosecutor's office in connection with the investigation of crimes. The maintenance of a workers' compensation file is maintained by risk management of the city and deals specifically with medical diagnosis, treatment, and payment, which does not go to the criminal prosecution of a crime. That said, the state would argue that therefore these particular pieces of information would not be discoverable under Brady or Dorman.
All right, now, the 15A-903 says what it says. But that's not the end-all be-all, because Brady doesn't mention 15A-903
That is
or
true.
a statutory scheme. It presents an issue greater than a statutory scheme, and that is based on the Constitution. This is my Constitution talk. So I understand, and I understand that part about 15A-903 and its definitions and that sort of thing. But it seems that Brady, expands that. It not only deals with law enforcement agencies and folks under that sort of imputed to be joined at the hip with the prosecution in every state, but other agencies that might fall within the scope of due diligence to see if there's any exculpatory evidence that might need to be turned over on a constitutional basis. So that's my question here, is are these workers' compensation, was it something that the DA's office should have, just in working with the many other things that you were working in your case, should that have occurred to you that there might be a statement made or some other information in a workers' compensation action that might be exculpatory toward the defense, and then is it the state's burden on those other agencies to seek out those other agencies to see if that happens? The simplest one to me is Department of Social Services. The DA's office does not control the Department of Social Services. But if you've got a sex abuse case, regularly there's inquiry by the district attorney's office as to matters dealt with by the Department of Social Services. Is the workers' compensation process analogous to that? So that, or did we just miss it at this point? There are many things that that were going on in investigation and defense. I'm hearing about this a week and a half into the trial. It could have been approached maybe by either side prior to it. I didn't think about it. I'm the judge assigned to this, and I didn't say, there might be a workers' compensation thing out there. Did y'all remember to look at? I didn't ask it. So I'm not casting aspersions on anyone for the timing of this or anything. What I'm really looking at is it a third-party agency that there might be some, and it relates to an injury. The injury is the subject of this criminal matter. And was there any information potentially in there that might be a statement by Mr. Stewart, or I don't know what else might be in there, but that's kind of my question. I'm not at the point at all, even close to the point where I'm saying somebody's trying to suppress this. There's something there and you're hiding it. I don't hear that. What I'm hearing is there might be something out there, we don't know, and it might have dealt with this, and is this just within the scope of due diligence that the prosecution would have to undertake in any case?
Well, Your Honor, we would say that workers' compensation claims would not be analogous to the Department of Social Services inquiry, specifically because it is well known that in rape cases, especially those involving minors, Social Services conducts their own investigation where they are speaking to many people involved about specifically what happened. Social Services is not an agency that sort of comes in at the end and then helps to pay for any medical or mental health treatment that would result or that would be needed as a result of the alleged crime. Whereas here with the workers' compensation, it's dealing specifically with the payment and the payment of the worker who was hurt and the paying of the bills. And if there is a claim filed, then that claim would be for the payment of the medical bills. Now, the medical treatment and diagnosis and all of that would be included in the medical records, which the state did exercise its due diligence and subpoena, and those have been submitted into evidence in this case, Your Honor. So we would say that no, these would not be discoverable under Brady or Dorman and are not necessarily within that scope of due diligence, because if we're dealing with medical treatment and diagnosis, we have the medical records. They've been turned over to the defense and they've been admitted into evidence in this trial, which, as Your Honor said, we are already a week and a half in.
Thank you. Thank you, Ms. Stroll. Well, here's kind of my take on it, is that the idea of the prosecutor has to exhaust every conceivable combination of circumstances to see if there's any exculpatory evidence. I don't believe it's the criteria. The criteria is whether it was due diligence, whether it was reasonable. In this particular case, if there were a workers' comp claim filed arising out of an injury suffered because of the very incident we're talking about here, which may include a statement, a claim in a workers' comp matter would include a statement of the claimant. Unless the claimant's deceased, in which case other potential witnesses or others may have statements in there. I do find that that is an agency that it would have been reasonable to think of that. Now, the fact that nobody associated with this case, and it didn't really occur to anybody, let's say, until here right of late, doesn't affect the possibility that there's a statement in there by Mr. Kelly Stewart, for example, that may be consistent with or at odds. And that would engender an in-camera review, because normally these records they may involve matters pertinent and relevant to the matter at issue here in this case, or they may not be. They may be talking about other things that really folks don't even know about, that you're encouraged to tell your doctor all sorts of things if you're, for example, talking to a doctor. How's it going with your spouse? Just a ton of things that are just not relevant here, and I jealously protect individuals' rights to privacy, and I balance that with the need to see whether this is something exculpatory that would benefit a defendant who's charged with a crime arising out of an incident. So I don't see it showing that. I don't at all approach the position that the state has done something intentional. And under the whole circumstance that Lisa is being brought up here during the middle of trial, indicates that each side had a lot of stuff going on, and each side was doing all the sorts of things that each side does to advocate for its position, and which sort of underscores to me there's nothing intentional or malicious or anything about it, but I think it's something we have to investigate. So the question comes as, and I don't know, as to how do you obtain these records this quickly, right in the middle of the trial?
Well, Your Honor, that is a question that we certainly can explore, and we thank the court for its ruling, and we also thank the court for your acknowledgement that this was not something that was an intentional attempt to suppress. But I would also like to note State v. Lynn, Your Honor, that says that while a defendant is constitutionally entitled to all exculpatory evidence, including impeachment evidence, in the possession of the state, however, is under a duty to disclose only those matters in its possession and is not required to conduct an independent investigation to locate evidence favorable to a defendant.
Well, I think that's clearly what I'm struggling with up here, and that's why I asked Mr. Charles about not only himself, but the others that were in the sort of chain of representation, is that this idea, even though it didn't occur to me as I was trying to perform my role in this matter, that's a matter that could have also occurred to the defense. And the defense has authority also to issue a subpoena and try to get the information And then we go through this whole thing, like I just described about, sure enough, one side comes in and moves to quash it, and then we have a hearing, and then they talk, and then we have ruling, and if the information's allowed, to be, or required to be produced, and the court makes an in-camera review. So that's part of why I was asking this question about, while it is the state's sort of responsibility, whether there's a request or not, to provide Brady material, and there is this requirement for due diligence, that doesn't mean that the defense can just sit back and do nothing to try to do its own investigation. It's pretty clear from Mr. Charnes's question that he's been engaging in a lot of investigation in this case. It's clear from the state's questions in this case that the state has engaged in a lot of investigation. And it appears to me that here's one area that might have not been addressed by either side. So, but it still may be evidence that's important in this case. So, what I'm going to ask the district attorney's office to do is to have somebody on staff make an inquiry into, you said it was the City of Durham Risk Management Division?
Yes, Your Honor.
Something of that nature. Let's see what it would take. I tell you, Mr. Charn, I'm not inclined to go doing another in-camera review of all those records from Duke University Medical Center, which were considerable, which would be potentially part of this inquiry of the Duke Risk Management Division. But I am inclined to do an in-camera on, their forms to file. And my goodness, I can't remember the last time I did a workers' compensation case in private practice, but I did them. And, there are claims to be made, and there's statements to be done, and then there are records to be provided, and there's a procedure. And whether with the description of how the event took place may have some impact on the final determination. I'll go ahead and tell you, I am not inclined to allow any evidence at all of what a separate tribunal or under the workers' compensation procedures decided ultimately in a case. That's they had a whole different burden of proof, had a whole, I don't know what their evidence was, but individual items of information that were presented, including statement of the claimant, may be germane to this matter. And that's what I'm asking the district attorney's office to do. We're not going to stop right now for any more of this, but we do need to see if we can obtain that information. And this sounds like it's going to be an ongoing visiting or revisiting to see how we stand on this. And you can, both counsel, communicate with each other about this without waiting to put it in front of the court. We can cover that, putting it in front of the court, and reconstructing your communications for the record. But you don't have to wait to communicate with each other about whatever the inquiries are in order to move this process along. If this were a separate injury, I would not be entertaining this motion at all, that it was something. I mean, it's a whole, the nexus is not there connecting to this injury and a workers' compensation that deals with something else, some other kind of injury. But it deals with the very same injury, and it has potential of some statements made, particularly by the claimant. So that's kind of the criteria. You can tell, I will give you all the information you need to obtain appeal and rebut on appeal, for the most part. So as to that's how we're going to address the Brady material request. Now, do we want to go ahead with the motion to dismiss prosecutorial misconduct? That's what I said I would do. I see now it's 20 to 12. But I am willing to hold the jury, or I'm willing to tell the jury they can go until 2:30. Let me hear what each of you want to say about that.
Your Honor, the state is in agreement to release the jury until 2:30 and go forward right now with Mr. Chalmers' allegations.
Thank you. Mr. Chalmers, let me hear from you.
That would be fine. I concur with the state. Let the jury come back at 2:30.
Thank you. Do you have anyone have any issue in my asking one of our bailiffs, is going to be Mrs. Sipple?
Yes.
Not Cycle. Sipple. Mr. Sipple. Mr. Sipple telling the jury that well, just telling that, ladies and gentlemen, you're in recess until and return back here at 2:30, and just leave it at that. Anybody have any issue with that?
Not from the state.
I don't particularly want to give them a reason, although they know generally, I've instructed them previously that there are times that we have to address matters outside of the presence of the jury, not speculate about. Okay, no objection to that?
No objection, Your Honor.
Then Mr. Sickle, if you'll let them know that 2:30. Here we go.
Counter, could Mr. Riley have some jury report?
I think I'm going to need one as well. I did not leave the bench. I did research up here on that. I know y'all were tied up in research. So we're going to let's take a 15-minute break, Sheriff, and that'll give Mr. Riley opportunity time for comfort breakfast for everybody else. Folks that are in the courtroom, the jury's leaving right now. Let's let them leave. Let's don't cat meet them at the elevator for right now. Let's give them a few minutes to head down, and then feel free to walk about the cabin. Thank you.
What's the recess? 15 minutes.
Thank you, Sheriff. Judy, thank you. I know that was a lot of intense talking.
It was slow. So it was
Okay,
nice.
yeah, it's okay. Well, no one will accuse me from being from Ohio or New Hampshire or somewhere like that where I would speak way too fast.
Like California.
California.
Yeah.
That's it.
Your Honor, permission to approach on a totally different matter not associated with anything of this.
Yes, ma'am. Mr. Charm, Ms. Ellis is approaching on something